Buckle up, guys. Today we are going to watch a father walk into court and walk out officially confirmed as a parent. The DNA results are in 99.999%. Visitation has been smooth, exchanges civil, even flexible. And now he wants more. Longer visits, weekends, even overnights. On paper, everything sounds cooperative. But when parenting time expands, scrutiny expands with it. What begins as progress quickly turns into pressure.
Beginning with the petitioning party in this case, would counsel announce appearances for the record, please?
May it please the court, Keegan Berry appears with Robert Moody, both via Zoom.
Joshua Andrews on behalf of Elizabeth Stout, who is also present in my conference room with me.
Court's docket notes indicate this matter last came before the court on March the 6th. At that time, the court conducted a hearing on motions. The genetic testing was not opposed. That was ordered. Court ordered visitation with the paternal grandmother present 10 a.m. to noon on Tuesdays, with the parties to meet at the movie theater between Winfield and Ark City. The answer out of time was allowed. Drug testing was denied. Review hearing set for today. Mr. Moody was to generalize that. Was that ever accomplished, Mr. Moody?
Judge, it should be uploading as we speak. I got the journal entry. We kind of went back and forth. Mr. Andrews had some proposed revisions, and I did make those revisions, got his approval today to upload that. So it's in the process of being filed.
Very well. Hopefully I'll see that in my signature queue sometime today. All right. Mr. Moody, what is the current status of this case?
Current status, Your Honor, is genetic testing occurred in about late April 18th and or April 19th on Mr. Berry and the minor child on or about April 22nd or so. Results came back, these 99.999% data. So in that regard, Judge, in addition to the journal entry from the last hearing, I have Mr. Andrews and I have circulated a proposed journal entry related to paternity, and that should be in your queue also as well with the other journal entry. As far as the visitation goes, they've been going fantastic. There have been no problem with the exchanges. There's been no issues. Paternal grandmother's been present at all those times. There's even one instance, Judge, where, because it was on Tuesdays and grandma had to be there, but she wasn't going to be able to do it one Tuesday. So the parties communicated and were able to reschedule that instead of a Tuesday to do it to a Thursday. And so it appears that the parties are able to at least communicate in that regard to be able to resolve any scheduling conflicts. And so that's how that's been going. Additionally, we're in the process of exchanging financial information and pay stubs so we can get child support calculated. I do think Mr. Andrews and myself will be able to get that done without the necessity of a hearing. I just got my client's information today, so I will submit that to Mr. Andrews so we can get working on those worksheets and see if we can get an agreed order in that regard. Finally, Judge, I think just today, when we would ask just for expanded parenting time, Mr. Berry, I mean, he's been doing it 2 hours every Tuesday since the March 6th hearing. Everything's been successful of all accounts. The minor child's.
Here's where a small clerical error turns into a big reality check. The judge catches a birth year mistake, 2027, and corrects it. The child is actually 15 months old, walking, mobile, curious. That detail changes everything. We're no longer talking about a newborn. We're talking about a toddler who can get into anything. Safety now becomes the silent centerpiece of this entire hearing.
Lights up every time she sees Dad, and they have a good time together. And so Mr. Berry's work schedule, he works night shift, Judge, from Monday through Friday. And that's why he's able to do the Tuesday at 10 o'clock. He would like to get overnights. I told him I don't know if that will happen. I mean, we're still just getting acclimated and trying to figure out the schedule. But our proposal, Judge, today would be to expand the Tuesday parenting time from 10 a.m. to 2 p.m. We'd like to get a third requested Thursday, same time, 10 a.m. to 2 p.m. And since Mr. Berry works night shift, he is available on the weekends. And so if you get it overnight, we propose Saturday at noon till Sunday at noon. But if the court's not inclined to give overnights, we request a Sunday with a block of time from like 9 a.m. to 5 p.m. or something similar to that, Judge, so that we can see how that goes and then come back maybe in 45 or 60 days before review date to see how that is going.
All right. Was a little thrown there for a minute, Mr. Moody. I was looking at the original UCCJEA affidavit in the case, showing the year of birth was 2027,
Oh,
which would make this child extremely young.
well, that tells me, Judge, that I did that and my secretary did not do that. That was my clerical error, Judge.
Now the tone shifts. The mother's attorney doesn't slam the brakes, but he definitely taps them. Concerns about drug use resurface, along with complaints about diet and consistency. Instead of jumping to overnights, he proposes a step-up plan, gradual, supervised growth. It's a cautious strategy. Expand slowly, test stability, protect the child. Cooperation remains, but trust clearly hasn't caught up.
All right, looking back at another document in the file, would appear that the child was born in 2024. I think it's pertinent to ask what month
Yes.
of 2024?
What month? April, February of 2024.
Okay, so this child is 14 months, 15 months by now, 15?
Yes, Your Honor.
Okay. Obviously walking, running, I
Yes,
presume.
communicating, verbal skills are on par with the 15-month-old.
Excellent. All right. With those questions now asked and matters clarified, Mr. Andrews, Mr. Moody's made a proposal to this court regarding expanded parenting time for who is now conclusively the father of the child. What is your position here?
Your Honor, my client does still have some concerns. Some of them we noted last time. They've not really been alleviated regarding, fears of drug use. There's been some concerns, just little things, for example, not following dietary restrictions during the parenting time, things that we're optimistic or hopeful that further experience and just getting used to being, a parent is going to help alleviate. So what we are suggesting is that the parenting time increase, that what we are requesting is that it increase from 10 to noon supervised on Tuesday to 10 to 2 unsupervised on Tuesday. And that
Here the judge drills into logistics. Housing, cohabitation, child accommodations, a bassinet for a 15-month-old. That detail lands hard. Preparation matters. Overnight parenting isn't symbolic. It requires readiness. The judge isn't attacking. He's evaluating. Does this father have more than good intentions? In custody cases, stability isn't declared. It's demonstrated.
we do that for 30 days and then add additional time after that if everything goes well. In fact, we would even be, I think, willing to agree to kind of what Mr. Moody had proposed. What we would be asking is we do 10 to 2 unsupervised every Tuesday for the next 30 days, and then do 10 to 2 and on Tuesday and Thursday of every week for 30 days after that. Something like that, to where it's kind of stepping up the time, increasing the time, making sure everything's still going well with that, and then review it as continuing to work towards that additional time, and hopefully seeing that there's still continued improvements with the parenting.
All right, Mr. Moody, what is your client's current living situation?
Judge, he's currently renting his home. He's got a stable home, and he's cohabitating with a significant other, Kate and Callaway.
Okay, and where do they reside?
Winfield. They're in Winfield, Kansas, Judge.
Okay. Do they live in the city limits?
Yes, sir.
Okay. Does your client have child-related accommodations that would even accommodate overnight visitation?
Yes.
Moody?
He does, Judge. He's got the bassinet. I mean, he's got car seats, he's got toys, and all the accommodations related for a 15-month-old.
Say a bassinet. Well, she's going to need a full-size child bed at this point.
Yeah. Do you have that?
We can get it.
So he's in the process of getting. He can get that, Judge.
This is the first real explosion. Methamphetamine, cocaine, ketamine, ecstasy, marijuana. The list is serious. and the courtroom energy tightens instantly. The judge responds with a high-stakes ultimatum: pass a drug test within 24 hours and get expanded parenting time, fail, and expansion disappears. Constitutional rights are acknowledged, but so is responsibility. Now the case hinges on chemistry.
All right.
That can be done immediately.
Yes, most definitely.
And during this parenting time that you're proposing, your client can commit to being there for the entirety of these periods?
That is correct, Your Honor.
How far away does grandmother live?
She's in town,
Like less than a mile.
less than a mile from Mr. Berry.
I trust that she's got a considerable amount of parenting experience.
Absolutely, Your Honor. Yes.
Mr. Andrews, these ongoing substance abuse issues that your client has with the father of this child involve what drugs?
Methamphetamine, marijuana, I believe ketamine, ecstasy, cocaine at various times.
All right. Mr. Moody, I'll give you an opportunity to confer privately with your client about this. What the court is currently contemplating here, Mr. Moody, is that if your client within the next 24 hours can submit to a drug screen for a minimum for the drugs of methamphetamine, marijuana, and cocaine and pass it, the court will grant all of the parenting time he's requesting. He fails it, he's not going to get any expanded parenting rights. Now that we've identified that he is the biological father, that there's no issue, he has certain constitutional rights to parent, which, in fact, quite frankly, he has a responsibility to help out with this child and maybe give mother a break once in a while, even on a weekend, where she can have a day to herself.
Then comes a surprising twist: honesty. The father admits marijuana use. Illegal in Kansas. The judge calls it a frank admission and even respects the candor, but that doesn't erase consequences. A simple urine test won't do. The mother's side pushes for a hair follicle test, the Longview method. The court agrees. Transparency just raised the bar instead of lowering it.
But she has to be assured that this child is going to be okay in whatever environment that she places this child in. And if there is some suggestion here at this stage that he's been involved with the dangerous street drugs such as cocaine and methamphetamine, not to mention marijuana use, then perhaps we should eliminate that as a consideration, which apparently is holding back the mother's willingness to expand his parenting rights. So, Mr. Moody, if you want to talk to your client about that and see if he would be willing to do that or not.
Your Honor, he's willing to do so, but I would inform the court if he did take a UA within the next 24 hours, it would be positive for marijuana, but negative for any other of those drugs that have been met, negative for any and all other illegal drugs.
All right. I trust your client traveled with you about that marijuana use.
That is correct.
Does your client know, Mr. Moody, that marijuana is still illegal in the state of Kansas?
He does, Your Honor.
He's not to possess it. He's not to use it. He's not to have it. He's not to be involved with it.
We have had that conversation, Judge, yes.
Well, that's a very frank admission. I'm actually impressed by it, Mr. Moody. I still want the test.
Your Honor, we would request, and my client is willing to pay the higher expense of a hair follicle test. My concern always, if there's a concern about methamphetamine use, is that leaves the system with anywhere from 24 to 72 hours, typically 24 to 48 hours. That it's not UAs are not a very effective way of detecting use of drugs like methamphetamine or cocaine. A hair follicle test is much more effective. And so my client's willing to pay for those costs for the hair follicle test, and that's what we'd be requesting.
Mr. Moody?
He's willing to do so.
Very well. That'll be the order of the court. I'm trusting that such tests can be scheduled. Mr. Andrews, do you have a proposal as to the sample gathering site and the testing site?
Your Honor, I would propose Assured Occupation Solutions in El Dorado. My client can go straight there to make payment. And if Mr. Moody's client can come straight from his office there, I think that timing would work out.
Mm-hmm. All right. See any problem with that proposal, Mr. Moody?
As long as they're open till 5 and he can leave right after here and head straight there, he's willing to do that, Your Honor.
All right. Much appreciated by the court. The real issue now before the court, Mr. Moody, I'll take you and your client's statements regarding what this test is going to eventually reveal at face value. What do we do with a father who uses THC? And this is the court's concern. This child is 15 months old and mobile. In fact, most likely highly mobile. Probably will get into anything that she can reach. Is that a fair statement?
Yes,
What
Your
I
Honor.
don't want is a parent who's impaired. Now, some people believe that THC ingestion doesn't result in impairment. This court disagrees. So those two are inconsistent with one another in the court's view. Use of these types of drugs and parenting. Mr. Andrews, your client threw out some really serious street drugs regarding her concerns regarding Mr. Berry's use. THC alone, what is your position?
I think my client's concern has been use of that immediately before or even during parenting time, based on the fact that the child has acted somewhat lethargic when returning from parenting time, has looked like she had some bloodshot eyes. Again, that my client may be looking at that through the lens of her knowledge and that Mr. Moody's client uses.
This segment cuts to the heart of the debate, impairment versus parenting. The judge makes his stance clear. THC equals impairment in his courtroom. The mother alleges lethargy, bloodshot eyes, even clothes masked with Febreze. The defense tries to separate marijuana from harder drugs, but the question isn't comparison, it's safety. With a mobile toddler, even mild impairment becomes magnified.
Marijuana, but that was a concern. Also, the fact that the child's clothes smell like they've been Febrezed right beforehand. These together, her main concern with the use of the marijuana isn't that this is limited to periods of time that the father is not around the child, but even when the father is around the child. And so, while it is not as destructive or damaging to the person as methamphetamine is, for example, where it really doesn't matter whether that's being used during parenting time or before, because the effects of that drug are so destructive that it makes it really difficult, if not possible, for somebody to adequately parent if they're using it at all. I don't know that we would go so far as to say that's the same thing with marijuana use, depending on how often it's being used. But the concern is with the frequency of use and when it's being used. What our concern is that during days or that he's exercising parenting time, that's our concern. And so again, we struggle with the idea of, it's difficult to prove that the use is going on because my client's not there. But that really, it was a big part of why we were recommending the unsupervised parenting time going forward, but without being comfortable with overnight parenting time, because we just think that with the marijuana use and how often that we're afraid that's going on, that any overnight is definitely going to expose the child to that.
Is this child generally awake from 10 to 2 during normal afternoons, Mr. Moody?
She has been from during the parenting time that Mr. Berry has exercised.
She gets tired about noon.
Yeah, she does get tired or more down towards the end of it.
Hmm.
So nap time used to be 11.
Hmm. All right, counsel, what the court's currently contemplating. Counsel, would you be available Wednesday, June the 4th in the afternoon
Yes, Your Honor.
at the same time, 2 o'clock?
Yes, Your Honor.
Mr. Moody,
Yes, Your Honor.
can we realistically think we're going to get results back from Occupational Solutions by that time?
My understanding and experience, Your Honor, is that if there's anything positive, then they send it off for confirmation. And so I would not expect results because we do have good reason to believe that it's going to be positive for at least the marijuana, which I think they would then send it off for confirmation on that, even if that's the only thing it's positive for. And so we wouldn't get the results back on the other stuff that quickly. I can make inquiry with Assured Occupation Solutions and see if they agree with that assessment. If the court would like to set this for that June 4th at 2, I can then call Assured Occupation Solutions. And if I find out, if they tell me that under the known circumstances that we would not have results back by then, I can email the court and Mr. Moody that and kind of just say, I don't think we would have any results by the 4th based on what they're telling me.
All right. Now, the court will set a review hearing in this case then at 2 o'clock on Wednesday, June 4th by Zoom. Hopefully, we'll have some sort of drug testing results available at that time. There will be a Tuesday, June 3rd visit period, however. I'm going to go ahead and keep grandmother involved in that one under the previous order of supervision, pending review of the case on Wednesday, June 4th. I do appreciate her continued willingness to be involved in her grandchild's life. And then the court will defer any rulings regarding expanded parenting rights until we at least have some indication from the drug testing what it reveals. So Wednesday, June 4th at 2. All right. Anything else that needs to be addressed at this time, Mr. Andrews?
No, Your Honor.
Mr. Moody?
None for petitioner, Your Honor. Thank you.
All right. All right. Hopefully that testing can be actually paid for and conducted today in accord with what's been discussed here on the record during this hearing. If there's nothing further to come before the court at this time, the Berry and Stout matter will currently be in recess, and this meeting may be ended for all at this time.
Thank you, Your Honor.
And just like that, the decision pauses. The judge sets a review date and keeps supervision in place until results return. No expanded time yet. No punishment either. Everything now rests on that test. Parenting rights are powerful, but proof is stronger. The next hearing will determine whether this father's honesty builds trust or costs him time. If you found this breakdown insightful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.